guys. Good, noon here. So morning, afternoon, nighttime, whatever you may be. And what we're going to do is take a break from some work around the house and talk about the Maya Kowalski case for a few minutes. Specifically, this motion to get a juror interview and for new trial based on alleged jury misconduct, that sort of thing. And see what the basis is for that. So some comments about it first. Some notes I made. Getting a verdict thrown out due to a juror issue, that's not easy. Everybody knows that, right? And it shouldn't be easy, okay? There's special rules that limit the amount of inquiry you can do, and especially regarding jury deliberations. So if you think about it, a unanimous jury verdict is in itself a buffer against one imperfect juror. So you'd never be able to have a final trial if you could just keep investigating jurors and going after them and things like that, and making up things and filing motions. So the courts are very reluctant to throw a verdict out just because somebody decides to complain about a juror. Think about the Johnny Depp case, right? They made a motion there saying the juror had lied about who they were and stuff like that. And oh my God, this is going to be thrown out, and it didn't go anywhere. How about the Charlie Adelson case was also in Florida, where he tried to create Chatgate, that the jurors had created a chat room or something on their phones and stuff. And we need to look into this, judge. And the judge is like, but what if we didn't look into it? So happy Thanksgiving to everybody. I think hopefully this means you can hear me, because we're going to get into this document here in a second. But I want to say some things about it before we get into it, to prep at least how I'm thinking about it, and you can agree or disagree. Trial jurors, when they're done, they're not sworn to secrecy. They can talk about it if they want to. So this juror in this case, juror number one, he could talk about how he felt about the case at this point and what he's thinking about it and what he thinks after it. There's nothing wrong with that. He can go on a line to support groups for Maya and say, hey, I was a juror on this case. That was terrible. They were terrible. If that's what he wants to do, that's what he can do. Okay. And we only have the defense version of this thing right now. The plaintiff hasn't responded yet. So this is the best case that the defense can bring out at current. So keeping that in mind as we look at what their allegations are. So the idea behind their motion here is, I think, a fair one. If a juror is, during the course of a case, talking to somebody outside the case, giving information about the case, getting information about the case, that's juror misconduct. That can result in a verdict being thrown out. That's fair, right? Now, whether that happened here or not, that's a different story. And what they're asking for here basically is an interview of the juror, and in this case, his wife, as a precursor to a court ruling whether the verdict should be thrown out, which they say, of course, should happen. Yeah, and somebody's making a comment when they were released, the judge said they can talk about the case. Absolutely. So the fact this guy's talking about the case after it's over, that's not harmful. Now, let's stop talking about this juror for a second, saying the abstract. If you go online or interview and you say, oh, they were disgusting fools on the defense side, I got madder at them as it went, and in the jury room we all agreed they're terrible, and that's fine. If you said, well, I wasn't sure how to go until somebody said, I'll give you $1,000 if you vote with me. You're free to say that, but now there's going to be a problem with the verdict, right? So it does depend on what you say, but the fact that you are talking is in itself not an issue. All right, so the allegations here involve one of the final 6 jurors, the one who made the decision. And in fact, it was a 4-person here. It doesn't involve deliberations between the jurors, at least not what I saw. Okay, so this is really about the alleged bias of this juror having an opinion during the case, already made his mind up, they say. And more specifically, they say there was contact between this juror and his wife where he shared information and she shared information, and that's what the problem is. Does the evidence show that? We'll take a look at it. They also say in here that the wife has a role as the wife of a 4-person. And no, she doesn't have a role as the wife of a 4-person. That doesn't mean what she does or doesn't do is wise or a good idea or not, but she's not sworn in. She's not a participant in this case. Her role is like anyone else's. Like, I mean, if I were talking to the guy, that would also be improper. So if he's talking to his wife about the case, that's improper. But the fact that she came to watch the trial by itself doesn't mean anything. The fact that it doesn't mean anything legally in terms of throwing the case over. The fact that she might have was posting online about it, that is also okay for her to do. The question is whether she and her husband were talking about the case. So you gotta partition that a little bit there. I mean, it's relevant because it's a circumstantial situation here, and so you have to evaluate it. But those things by themselves, they don't they don't show anything. Like if the guy said, well, I took $1,000 to vote this way. Okay, case over. Let's get a new jury in here and do this again. That's not what this is. It's nowhere near as clean as that, but it also doesn't look good either. I think that's fair to say. So again, we already have the precedent there in the Adelson case where the judge was like, I'm not going to get into this. Now take the Murdaugh case where it's alleged that the court clerk was talking to jurors. That's getting quite complicated in that case. So everybody, I think, probably does agree and ought to agree in the abstract that jurors should do what the judge tells them to do, which is not talk about the case with other people. That's the jurors. And if somebody tries to talk to them about the case, they're supposed to tell the judge that. So that's what the jurors are supposed to do, and we all agree that should happen. And we all know that lawyers will, if they lose, try and find any way they can to create a way to get out of the verdict, either at this motion level or at the appellate level. And you just have to look at the facts and see whether it really amounts to anything or not. All right, so let's take a look at what I think would be good to look at first, which is what's the legal standard here? Because in the law, you can't just assume the rules make sense like they would if you just were imagining them in your mind. So for lawyers, at least, it's always important what the legal standard is. The burdens of proof in a case, at the appellate level, the standard of review that's going to be given, all those things matter. So let's look at what the defense tells the judge, hey, here's what the legal standard is, and then we'll go back and look at the facts and see if we think it fits it or not. Because there are some interesting cases here where verdicts have been thrown out because of what jurors have done, and then they try to do what any lawyer would do, is to say, our case is similar to this because of this, similar because of that, and for that reason, judge, you should bring the juror in and also throw this verdict out. So at any rate, we'll take a look at it. Now, is this a Hail Mary or not? I see a comment on that. You file all kinds of motions at the end of something like this, and especially, to come on with a verdict that's $250 million, you're gonna file everything you can. But for all these things, I think if you're going to look at it, you don't just go ahead and assume, well, they don't have any leg to stand on without reading it, because how would you know, right? That's reasoning backwards. So we were going to give this one a fair shake. We're going to look at what the standard is and see what actually happened. And we won't assume just because the wife was talking about the trial while it was occurring that means this verdict should be thrown out. And we won't assume just because she was talking about it that there's no reason to review it. We'll look at actually whether they have a basis or not. So the legal standard they put up here, they start out, as you'd like to do, in a very benign way. A party can move for a juror interview if the party believes that grounds for a legal challenge to a verdict may exist. An interview for a juror is proper where there's a reasonable basis to believe that a prejudicial act occurred supporting a legal basis for a new trial, such as improper contact with a juror or misconduct of a juror. So there's evidence for that. You can move for it, and the judge can look at it and decide on whether that's something that needs to be looked into or not. It seems fair, doesn't it? So far, so good. And you don't have to conclusively establish this when you're just moving for the interview. And that's true too. So let's take this Murdaugh thing. They're asking for an evidentiary hearing about whether the clerk talked to the jury about the matters of the case. They don't have to prove it to get the evidentiary hearing. They just have to show a basis for it for the judge to look at it and go, yeah, I think that's enough. We better look into it. And then you can see whether they show it or not. So that's what they're having to do here. But again, it's not so easy to convince a judge to do this, as you saw in the Adelson case. It's not just, if you come to me with any theory that you're butthurt about, then we'll haul the jurors back in and talk to them about it. You need to come with some serious receipts. So we'll take a look at that in a moment. In contrast to what is needed to prove entitlement to a new trial, a party seeking only a juror interview must set forth sworn allegations that, if true, would require a trial court to order a new trial. And that's true. So if another way you have to look at this when we get into the facts is, if the things they say are true, the facts, not the inferences, if the facts are true, would that mean for the judge, yeah, if all of that happened, I'd have to throw this verdict out. And then you should have some evidence come in to see whether it did happen or not. But if all you did was accuse the juror of something that wouldn't result in the verdict being thrown out anyway, then there's no need to have a hearing. So you also have to show that what you're alleging would amount to something that would cause a verdict to be thrown out, right? That makes sense too, I think. So let's take a look here. Blah, blah, blah. So they're very reasonable. Everybody agrees with the defense at this point, right? That we're all going to operate under this law. Once improper contact or jury misconduct is established by jury interview, and that assumes that it is established, the moving party is entitled to a new trial unless the opposing party can demonstrate there's no reasonable possibility that juror misconduct affected the verdict. We can all still agree there too, right? If the improper contact or jury misconduct is established, then it throws over to the other side to say, hey, that didn't really matter in this case. So, okay. Let's keep going here. So the first thing they say, there's only a couple of these. Evidence of juror misconduct undermines the integrity of the judicial process and warrants a new trial as a matter of public policy. A jury who's biased or prejudiced is not fair-minded and impartial, and that's required to prevent impairment of the right to a jury trial to have jurors who are impartial. That's fair. We're all still agreeing, right? And it's kind of hard when you're stating the standard of the law to say things that don't make sense to the judge, because then you just get called out for that. If you say the wrong standard, your motion's in trouble right off the bat. Okay, so let me show you the cases that they're citing so you can have those in your mind when we go back and look at what is alleged here. So here we have a case in Florida where the jury foreman, and I'm sure they queried in their research tool jury foreman and misconduct to try and find these kind of cases. The jury foreman and his brother, who was an agent of the defendant's liability insurer, they discussed the case a couple of times, although they say they didn't discuss substantive matters concerning the case. And of course, the judge had instructed the jury, do not talk to other people about it. Do not do that. And don't form an opinion. But the offending juror admittedly engaged in two separate conversations with his brother regarding the case during the 3-day trial. Now, remember, the juror said, but it wasn't of substance. But the court said, you're talking to your brother about the case, and further, your brother presumably has some prejudice toward the defense side on this. We're throwing this out. Now, you can imagine where the defense here is going to go with that. Jury foreman, a relative. The relative is on the other side. Hey, judge, it's exactly like this case. But is it? Is it? I think one critical fact here is the juror here admitted that he had conversations about the case. So that's going to be something that gets distinguished for certain. Let's take a look here further down into it. Objective acts, blah, blah, blah. Relationship to the brother, undermine the, yeah. So we already did all that. And what I'm doing here is skipping their application of this law to the facts that they cite, because we'll do that ourselves. We don't have to take their conclusions. We're just looking at the law that they're offering. Then the next thing they say, defendant is entitled to a new trial if the juror interview establishes improper contacts and communications between this juror and his wife. And they have a lot of things about tweeting and blogging, but I want to get down to where I looked at the case. Extraneous influences demonstrating the existence of partiality or bias may be shown by communications or other contact between jurors and third persons. We all agree with that. So in Gaffney, two jurors readily admitted they discussed the case with their spouses. Yes, they readily admitted they discussed the case regularly with their spouses. And that's direct contravention, obviously, to the instruction that you get. And that creates a possibility that the jurors considered other evidence. Discussion with family members about the case cannot be dismissed as harmless. So naturally, the defense would bring this case into play too, saying that, hey, what we're showing here indicates that this juror and the wife are discussing this case. And that's the kind of thing that can get a verdict thrown out. This was a cool one, the Stouffer case. There was a nonverbal communication between a juror and a juror's spouse. So they didn't even talk about it in theory, at least not that anybody could prove. There was repeated nonverbal communication between the juror and her husband. She looked at her husband with a questioning look on her face, and the husband responded by nodding and rolling his eyes. And so at the trial level, the trial judge said, there's nothing more here than speculation that these people talked about this trial, denied the request to examine the juror. Now, examining a juror is not the same thing as getting the case overthrown, the verdict overthrown. That's the initial step of whether it should be looked into or not. And that got reversed, that the timing and context of the nonverbal communications and the specific observations strongly indicate they were discussing matters before the jury. And the failure was not investigating it. It's implausible that the communication did not favor either side. So even though in that case, the juror said, I refused to talk about the case when my husband tried to talk to me about it, the appellate court said, you can consider the juror's credibility here against the circumstantial evidence, and that's what you should do. And that the proper remedy was a hearing to see whether this really happened or not, what kind of prejudice there was. And then here's another one where the guy said he was talking to his wife or whatever. And And they're quoting this because the court can assess the credibility of the juror, because they also anticipate if they have this juror interview that the juror is going to come in and say, I never talked to my wife about this case until it was over. And what evidence do they have that that's not true? So that's what the story is. So these are kind of the cases that they have here. And it's a very reasonable law that there shouldn't be improper contact between a juror and someone else. And some of the stuff I skipped over, they're trying to pull the wife's actions in to say, look at how active she was in this case as evidence of wrongdoing. And it only is if it causes the court to believe that the husband, who was the juror, was talking to her about the case or listening to her about the case. That's how that becomes relevant. Otherwise, she can do what she wants, pretty much. Let's see, Kurt, you're saying Kurt did a 4-hour stream on it. We will not be doing that. So we won't be doing 4 hours, but Kurt gets into details and does a lot of great case analysis. So I'm sure if you had watched all 4 hours of it, it would have been time well spent, because he really does do a great analysis on appellate cases as well as the facts of the case. And I see Rob mentioning here too for Law and Lumber, and that's going to be something we look at now that we're going to get into the facts. And of course, I didn't have time to watch what he was streaming on it because he was doing a lot on the case. But I will note that when the juror came to him and said, I'll do an interview with you, Rob said, let's don't do that. So, Rob was, I'm sure, at all times doing the right thing on this, and just commenting on the case, and and never did anything wrong on this case. And there's absolutely nothing I saw on that. And I don't think they even try and accuse him of that in this. They're just pointing out how much this juror and his wife wanted to communicate with people about this. Now, this juror's communication, of course, came after the case was over, so that's not improper in and of itself. Now, here's a good one that we'll get to. There's no way they didn't discuss it. I'd bet my life on it, but no way to prove it unless they get the devices. They have asked for an emergency order to preserve these devices. But again, you're asking a lot of the court. You're asking a lot of the court to go digging this hard into the case. But there is a case mentioned in here that I didn't talk about that they did, where there was evidence that a juror had deleted search history and some messages, and the court said that's evidence that you were looking at stuff you shouldn't have been, or you wouldn't have been needing to partially delete these things. So the court can look at the circumstantial evidence that's around this and decide what they want to do. They don't have to have an admission by the juror, but it sure would help, and I don't think they're going to get it here. The juror's not going to say that. The juror hasn't said that. The juror's never said that he talked about the case while it was proceeding. So let's take a look at some things that got highlighted here for the facts now that we've looked at the law a little bit. All right, so we already went over this, and we all agree that contact with the juror during a trial, that's not good, and it can be bad. So we all agree with that, but did it happen here? All right, this is in the summary, so I think we've covered that. They're saying that considered in totality, which is the right way to consider evidence. You don't pick out any individual piece and go, well, that doesn't prove it, or that does. You look at all the evidence, and this is true in a criminal trial or civil trial, and decide then whether the material facts are established or not. They say the evidence provides a reasonable basis for a belief that the juror disregarded his juror oath and this court's instructions and engaged in improper juror communications and contacts, which is what they need to say if they're going to make this motion. In addition to the presumptively presidential style, the juror's wife's involvement on social media during the course of the trial, and she was hog wild on this, apparently, just commenting on left and right on different YouTube channels and things. And one of the things they point out here, which is interesting, is that they say that her comments on the case from YouTube channels and Facebook and stuff like that didn't occur only during the day when her husband was on the jury, but also at night when he would have been at home with her. She was still online commenting about things, and they say it's only natural to think that since they're in the same location together, both interested in the very same case, that there would have been some dialogue about that. And then, of course, they're going to say that you can see that between the lines. Factual background. Looks bad for the jury and the parties. Live streams had no contacts with jurors. Yeah, I mean, the live streamers who were summarizing the case, they weren't doing this stuff. So, yeah. Let's see. Anyway, yeah, you might want to talk to anyone who would listen and all that. Yeah. Again, I think it's not to say that the wife can't get on social media and talk about stuff. This all comes down to whether you believe that what she was saying, the content of it, indicates she was talking with her husband, and the timing of it. That's what they have to show. That's what they'd have to convince the judge of. So her social media history reveals her personal engagement with the public commentary of this trial. It's unlike that of a member of the public who shares a general interest in the case. It's particularly inappropriate given her role as the wife of a jury foreman. And again, I'm going to stop there and say, if I'm the judge on this, she doesn't have a role as the wife of the jury foreman. Okay, she did whatever she did, and you need to show me that that means that he had contact with her. She doesn't have a special role. I get it. He lives with her, so if she's talking to somebody out loud on the phone and texting and stuff, you're going to tell me he heard that or participated in it. Show me that. She doesn't have a special role herself. She's the one, not the one under the obligation here. All right. Let's see. Somebody says they think it was a troll that super chatted Rob's stream. That's always possible too. And you know, if that's true, maybe the plaintiff will come back and say that. But again, I don't think Rob bid on any of that, and he wouldn't. He's too smart, and plus he believes in the integrity of the system. So I am confident, highly confident in that. And the people with the most to gain by alleging bad acts, the defense in this case, because they're the ones who want to overturn a verdict, didn't accuse any of these people of anything. So that's not in the picture. She also came to the trial, right? She physically attended the trial proceedings, and they're saying she sat with some online person who was talking about the case, who was highly associated with the plaintiff's side. And I think it is fair to say that you look at how the wife behaved there, and as well as what she's saying about the case while it was in progress, she was way on Maya's side. Okay, that I don't think you can argue about that. It's not wrong for her to think that if that's what she chooses to think. And they're saying the juror number one said nothing of her presence. He doesn't have to tell anybody at court that she's in there. Why would he have to do that? Who's he supposed to tell, and what are they supposed to do about it? So again, sometimes, you know, they have some things that are interesting to think about, and then, like in anything, you may lawyer a little bit too far and you start piling more things on that are like, eh. So there's a comment, of course, spouses are going to speak with each other, but how are you going to prove it? Okay, and that's the question, right? Especially when the bias is to leave verdicts alone. But it's really up to the judge to decide it. And if the judge were to decide, well, because this is what they try and argue, that the wife wouldn't have known X if her husband hadn't told her, because there's no way for the public to know it. I think there would be a fair inference from that he told her that, or vice versa. You know, if he knew something specifically was happening during the case, then there's no way he could know unless somebody told him. You know, you can go with some inferences there, but to some degree, that's a strained situation here, even though the wife was definitely wrapped up into this case. All right. Let's see what that. Anyone who didn't go along with the mob was labeled a troll, including on Law and Lumber. Yeah, that's can certainly be the case. So anyway, let's keep moving here. So they're saying that the wife and this person exchanged phone numbers and made plans and all that. And I saw some of that in their exhibits, and she was seated next to him and stuff like that. And so again, okay, and she's free to do that. The question is, did she talk to her husband about the case? Okay, I got it. I got it that she was on Maya's side, and that she said that out loud to anybody who was going to listen to her online, and sat in court and all that stuff. Did she talk to her husband about it? That's the question. And did he talk to her about things? And then he called this person notorious. That's a loaded word too there, right? Noteworthy could be a different word if you weren't trying to pump that a different direction. And let's keep going here and get down to some real facts. So the wife allegedly was heavily engaged with the trial online both before and after she physically appeared in court, posting comments about the case that are pro-plaintiff. And I think that's fair. I think if you read the record, unless you're going to say it wasn't her posting, and that might be what happens, but if it was her posting, she's definitely on the side of Maya there. Again, she can do that. Okay, let's remember, she's not the juror. Okay, you still have to connect this. There are a lot of people sitting in the courtroom and a lot of people online who were pro-Maya, right? What makes this person special is that she's in the house with the guy, and then you're going to have to show that while they were together behind closed doors, there's this communication going on. It's not the mere fact that they're living together or married or whatever. And with the admirable name Hippo Lover is what she allegedly was talking to. Let's see. Real time and after the day ended, the jury was sent on. So this, I think, is, if you're going to try and start saying, okay, judge, here's all the smoke of the someone very close to the juror being super pro plaintiff and involved in the case, searching the docket, setting in the trial, stuff like that. Okay, well, where's the flames at? So they want to try and establish it here, saying that the wife was posting, engaged in commentary about the trial online in real time, okay, so during the day, and after the trial had ended when the jury was sent home, including her husband. So the husband comes into their house. I don't know what the size of their house is, their living arrangements, or anything else about them, but allegedly, in theory, she's in the house, he's in the house, and she's online talking about this case. There's two different things that could mean. First is, does that mean a judge should go, well, I tell you what, based on that, I'll call the juror back in and ask him, when your wife was doing this stuff when you were at home, did you hear any of it, see any of it, or talk to her about any of it? And then he's going to say no. And then the judge might go, okay, that's enough. Or the judge might go, this isn't even enough to cause me to do that. This wouldn't result right now in any leap to, well, oh my God, let's throw this verdict out. The best thing this could do would probably be to ask the juror, and then the judge could decide whether that's believable or not. But this is at least trying to connect the idea that this particular person, the wife, and her pro-plaintiff discussions could have flowed over to the husband. And then they also say the information that was posted indicated this. And there's some stretch in that, I think. But, they're trying to pad this up. She's donating money and stuff like that. Again, we get it. She's on Maya's side to a high degree. Yeah, the judge asks every day where you can talk to anybody, and they say no. So, right, of course, right. So that doesn't mean that that you don't get to bring this up. But again, Adelson brought it up, and the judge said, "Yeah, that's a cool story, but I'm not going anywhere with it." So this is a little different than Adelson's case, though. I have to say that again, everybody's free to do what they want to do. My suggestion would be that if your spouse is on a jury, that you tamp it down a little bit, because you could be causing an issue here. Just tamp it down a little bit. But that's just a suggestion. You do what you want. You don't have a personal obligation. But then you may find yourself in a firestorm like this. So they say it strains credulity to believe that these people were not discussing the case in violation of the court's instructions. To the contrary, the evidence provides a reasonable basis to believe they were exchanging information and beliefs. So they're trying to say, listen, she was not only talking about this case while he was at home or released for the day, there's also information in what she posted that indicates that she was talking about the case, or otherwise she would have known it. I don't think it's as clear as they say, though. It's just in my opinion. For example, she says, here's a good one that they bring out. While Detective Graham was going on the stand, she comments on somebody's channel, the juror Leo, which was her husband, will be asking questions. Now, does that mean that her husband said, I'm going to ask questions when I get in there? Or does that mean that she knows her husband, she knows how he is, and she's thinking he's going to be asking questions of this person because he was former police himself, and he's going to have procedure questions. So again, are you going to get the judge curious enough about this to say, well, given that she wrote that, I want to call him in and say, did you tell your wife you were going to be asking questions? And then he says no, and that might be the end of it. Or the judge may pull an Adelson and say, there's nothing in this that tells me that he talked to her. She didn't say, the juror Leo told me he'll be asking questions, right? So you have to infer that from this. And of course, I think he did ask questions. So the day prior, she pretended a challenge by her husband, Detective Grant, LEO officer, juror LOL. So again, referencing your spouse's jury service during the trial online is a way to get yourself involved in a motion like this after it's over. Again, I'm not saying she shouldn't have opinions on the case and things like that. We're just talking about the wisdom of talking about it while the case is in progress. Yes, and somebody's saying, we were all saying that the LEO juror was going to ask questions. And that's my point. That's my point. And I agree with you there. Like, okay, so she knows her husband's LEO, and I guess everybody did then maybe at that point. So is she saying, oh, he's going to be asking some questions about this? If she just thought that because of her general view of him as a husband and stuff, and he didn't talk to her about it, then this is that part of it isn't much ado about nothing. Somebody says it's a common practice it's a common practice to find any basis you can to appeal and then appeal it. And because you might win on something, and also it slows down the case. And ultimately that can lead to, although this is kind of an extreme case, a settlement somewhere for less money than was originally awarded. That is often the case. And then, of course, sometimes it can result in a successful appeal. But yeah, there's a lot of money at stake here. And it would be insane not to, even if you did want to settle it, not to create as much leverage as possible by filing all the motions and basis for appeal that you can. And if you're their lawyers and they want you to do it, it'd be kind of malpractice not to do it. So let's see here. Spousal privilege and stuff like that. Well, I think the thing is, he can be called in, and they're going to say to him, if they were to call him in, did you talk to your wife about this or not? And if he wants to go, I'm not going to tell you that. If I'm the judge, I would say, well, I guess we'll just do us a new trial then. I don't think he should hide away from this. If he were called in, and I'm not saying he will be, I think he should say, I didn't talk to her about it. No, not until after the deliberations were done and the verdict was in and the judge said we were free. Then, oh yeah, we talked about it. And I can't believe all the things she said, judge, oh my God, she was all up in this thing. I didn't even know it, But we were very careful at home not to talk to about each other and stuff like that. So I think if he gets called in, that's probably what will get said. But yeah, I think not everything you can do is everything you should do, because sometimes it makes life more complicated. So here she says that the wife was apparently okay, this is a different one here. The wife says, paid to Super Chat, I think the note yesterday was a frustrated jury that cannot reach a dollars agreement and it will take days. And now they're saying the wife was apparently interpreting the juror's thoughts in relation to juror number one's question the day prior regarding a request. Her comment contained inside information she could only have obtained from her husband. Now, I will certify here during this stream, I don't know her or her husband, but I viewed that question and the note to the judge there as an indication that they cannot reach dollar agreements and it will take days. And I don't think you have to be any expert at all to get that out of what was said there. And a matter of fact, as I watched the case as it went along from the tidbits I could catch, when I first heard about it, I was like, oh, a Munchausen case. Oh, that's sad. And then after that, I heard, oh, well, maybe the hospital was at fault here partially or largely or whatever. Then a little bit of a start of it. And I thought it started kind of slow. But by the end of it, I'm like, the plaintiff has got the rhythm. This is about how much money this case will be. And it was, it should take days for a $250 million verdict. There's nothing wrong with that. So here, I think you have to read the wife's mind. She didn't say here, I've got the inside scoop. There's no verdict coming back anytime soon. Or that LEO juror, he is not happy with this. There's no direct thing here that says she talked to her husband. She's making a comment there that I think probably about anybody would make about the case. That doesn't mean she didn't talk to her husband about it. What I am saying, to me, what it means is there's nothing you can draw out of this that says she must have talked to her husband to have this kind of insight about the case, because I don't think that's particularly insightful about the case. Plaintiff's lawyers have admitted they relied upon advice and observations from YouTube streamers during the trial. Is a good comment, and I think that is that's fair too. And maybe they should do it if you got, I guess, time to do it. And there are, these days, people watching cases closely. You can find some interesting things out. I meant to make this bigger so you can make sure you can read it. All right, so we went over the Super Chat comment. And that it would only, and they put it in italics too. It could only have been obtained from her husband. But I just don't see that here, right? Logically, I think if you've got an ultra excited spouse like that, that's talking online all the time, including when you're home, there's a pretty good chance there was a discussion there. But it doesn't mean that it did happen. And I don't think that comment proves to me that it does. That's my take on that. And then she said the jury did not like this witness or any of the witnesses defendant presented at the trial the day prior. How would she know that without talking to her husband? So I don't know. When you say the jury didn't like them, that is at least giving a direct indication that you're speaking about the jury's mindset, like you know what it is. Now, of course, her husband, even if he didn't like these people, wouldn't know whether the other jurors like them or not, at least in theory, because they're not supposed to talk about it. I would have thought that during some of these witnesses' testimony, I found a lot of the defense witnesses arrogant and aloof. That's my opinion. And when I watched what I could watch, and if I were sitting in the jury, they would be rubbing me the wrong way. Is that what she's saying here? Or is this the inside scoop from her husband, right? Yeah, how could she have known that the jury liked this witness aside from information she obtained from her husband? And I guess it all depends on how you read that, right? And this is in italics again. I get what they're saying about the circumstantial things, but these aren't, to me, these aren't smoking gun comments. That's my opinion. Now, again, I could see potentially the judge saying, okay, you got to come in here and tell me whether you talked to her or not. That might happen, but I don't know that it'll do that, because usually these things don't go anywhere, but every once in a while they do. And then she's talking about what she researched on the docket, and that's fine. We know she was interested in it. I researched things on the docket and Googled the judge and all that. And so, yeah, she was super into the case. And I guess that's part of the circumstances, that if she's into Googling it and researching everything that's on the docket, and yet she has a juror sitting in her house with her, is she really not going to say anything? That's the part of the defense theory here, right? Let's see. This is more about how favorable to the plaintiff she was. I wonder if the defense are getting witnesses to have Anderson burn out his time. Anderson, please, we need you. Who's the we there? Who's the we we're talking about? If she wrote that, right? So we need you is a pretty much Team Maya, right? But again, I think it would be crazy to argue that these things don't show that the wife was favorable to Maya's side of the case and was hoping that she would prevail. It does. And she's free to have that opinion. I don't think I can. I hope I'm not being confusing on that. I hope not. So that's my opinion of that. Is it wise to express that opinion in that way during the course of the trial? I would say hopefully people wouldn't do that. That doesn't mean the trial gets thrown out in and of itself, though. How could she know that the plaintiffs were running out of time if she wasn't discussing the case with her husband? Again, I was no careful observer of this like Rob was, but I watched bits of it, and I knew that the guy was running out of time, because every once in a while they talk about how much time do we have left. If you're watching a trial, I think you would know that, and probably there's some commenters who will back me up on that, I think. And somebody says, I just think it looks bad. No, yeah, I agree with that. So, they've created some smoke here. The question's whether there's fire there, and I appreciate this. I'm not a lawyer. That's good news. And happy Thanksgiving to you, U.S. friends. Thank you very much for everybody who does celebrate it, and just a great weekend for those who don't. Let's see what else they got in here. They got any more? Again, this is all about the bias. That's why I'm not talking about every bit of this, because I'm agreeing right off the bat. The wife was hoping Maya would win. The wife was absolutely thinking Maya was right. The plaintiff probably shouldn't really try to argue that more than they argue that she can have whatever opinion she wants. So, yeah. Yeah, shot clock was a big deal every day. We all knew that. Yeah, I knew that, and I wasn't watching the whole trial. So, and did the judge mention time constraints for the plaintiff several times toward the end? I thought that too. So, yeah. And here's a good comment by Kevin. If the shoe were on the other foot, the mob would be burning down the public square because the hospital had an administrator's spouse on the jury. And possibly so. We all know that often when people look at cases, when they pick a side, they start to view the events that happen in relation to how they already have a narrative in their case. And whether it's a criminal case or especially civil cases, it's not a question of angels versus demons, right? Like you don't have to be a perfect angel to have been a victim in something. A lot of victims have maybe done something bad themselves or imperfect in some way. That doesn't mean they're not a victim. The lawyer who's prosecuting the case for them can also make mistakes. It doesn't mean that they don't have a good case. And you don't have to be evil to be liable in a case. So not everything the defense does is terrible, and not everything the plaintiff does is great, or vice versa in either case. So I think Kevin's right there. You're going to have a variety of opinions without respect to what the facts of the particular motion are. So here, I think the best you can do is boil it down and say the strong bias is verdict stand. The strong bias is that we don't put jurors under ridiculous levels of scrutiny unless it's truly warranted. And then you look at this and say, is there evidence that this guy talked to, in this case, it happens to be his wife. It could have been somebody else. But in this case, that he talked to his wife about the case. That's really what it is. Is this evidence he talked to his wife? And that should be, as you point out, should be the same kind of theory, whichever side was making this motion. You should look at it and say, is there evidence of this? And then there's more talking about that. The internet community was made aware of the bias in plaintiff's favor on the part of a juror's wife. plainly compromising the integrity of the jury process. And again, this is where I think if you can do it, maybe you shouldn't do it, is my theory there. As his wife and household companion during the course of the 9-week trial, she was serving as his agent to the internet world. And I think that's an unfair thing for the defense to say there. I mean, let's say, for example, he and his wife are not talking about the case. Then how's she his agent to the internet community? In his mind at that point, he doesn't have any idea that she's out there talking to the world about the case. If he is talking to her about the case, then maybe you could make this argument. But at that point, you've already won anyway, because even if they didn't tell anybody else that you're talking about the case, if it comes out that they did, that's just as bad as if she's on the internet doing it. The internet is just hypothetically some evidence of her bias and stuff. Taking a look at some comments here. He blatantly was biased even during the questions. Yeah. And there was a discussion here, which I think I have flagged there, when they tried to get him off the case at one point, and the plaintiff's attorney originally, I think, was going to go along with it and change his mind. And here it is. So this is when the defense had made a motion at one point to have this guy taken off with the jury. And in theory, at least, I didn't catch all of it, Anderson was not going to object to it, or was kind of agree with it. I'll agree with you, it says he says. But then, as the court was outlining the agreement of the parties and identifying which alternate would take Juror 1's place, Anderson announced, you know who I didn't check with throughout this whole thing? My client. And then 15 seconds later, he changed his position yet again. I'm going to go with my client. I have to switch positions because my client feels more comfortable with Juror number 1. I'm going to switch positions based on my client's input. In response, Mr. Kowalski can be seen turning to this person I talked about earlier and nodding his head with a smile. Now, what does that mean? You know, what's that evidence of? I guess I would say it's somewhat unusual for the client to overrule the lawyer in the middle of a trial on which juror to keep, and to do that within a few seconds. I would say that. They normally are going to trust the lawyer to do it. That's why you have the lawyer. Let me say this, for example, sometimes during voir dire, when we would talk about jurors and things like that, or different matters, we would, I don't know if I should, I'm going to tell you. So anyway, we would tell the client, listen, we're going to turn around and we're going to talk to you about this, okay? But we already know what we need to do. But even if you don't have any ideas, let's look like we're engaged in a discussion, because what you're wanting to do is create for the jury the appearance that you're a team. You're equal valued members with each other and stuff. So sometimes that was a little bit of a show. But normally speaking, the client is going to go, look, if you think this is okay, then I'm okay with it because you're their lawyer. So let's see. Gag order in the future with a jury member? No, of course not. And you can't do that. You're not going to be able to do that. The only question here is it a good idea to do all this and come to the trial and stuff like that when your spouse is on a jury? If you think that's a great idea, then okay, because I have to agree that I don't think the spouse is under an obligation, nor should they be put under an obligation. But there is also the idea that sometimes handling things in a way that makes some sense can be a good idea. And I don't know whether she went fully overboard here or not, but I am saying that I would probably counsel against talking about the case. If somebody asked me, hey, my spouse is going to be on this jury, do you think I should be talking about it on YouTube Live and stuff like that and going to the trial? I would probably say, for the sake of the trial, just don't do that. How about don't do that? But that doesn't mean you can't do that or that sort of thing. So don't trust lawyers, any of them. Yeah, it's fair advice, but you know what? Don't trust anybody. How about that? Because there's not the reason why I'm big on process and trying to distance yourself from your own personal narrative of a case is because there's no human institution that is free of fraud, because they all have people in it, whether it's religion, car sales, lawyering, medicine, especially government. Basically anything you can find, you're going to find wrongdoing in it because there are people in it, and the screening process is not perfect. So the idea behind the law is you try and create a process that works as good as it can with all the flaws that it does have to reduce the amount of potential for this sort of, that somebody's personal misconduct would influence the outcome to a way that couldn't be corrected. I'm not talking about the jurors here, I'm talking about lawyers. Let's see. if they talk to each other, I don't think anything's going to happen other than they might get a new trial. That would be probably the worst case outcome on this. But I don't know that that's going to happen here based on what I'm reading. Because even if you think, they probably talked about that when they were in the room together and stuff, did that equal establishing that? And then they talked about some of the things when the case was over, the juror came out, juror number one, and was liking things and saying who he was and stuff like that, and liked a meme about the judge and stuff. But you know what? He can do all those things if he wants to when the case is over. He can do that. Now here's another one where they say here's evidence he knew what things that he shouldn't have known, because again, you got the wife heavily engaged in the case. You got the wife allegedly talking about it online when this guy's home. But you're wanting to show that there was communication between these two, because that's the wrongdoing if there is any. And so they're saying this juror said, oh boy, I'm in trouble once again, when he was asked by a lieutenant to hang behind. And so they're saying the oh boy, I'm in trouble once again was him referring to a prior occasion when they were trying to get him off the case. And in fact, that's what they say here. Juror number one's comment about being in trouble once again indicates that he knew prior to being released from the courthouse that they had tried to move him to dismiss him as a juror. Is that what it is? How do you know that this lieutenant didn't get on him before about, like, you can't go in that room over there. You're retired. You're not allowed in the authorized personnel room only. You can't get more than one snack out of the snack room. There's nothing in this statement here that says I'm in trouble again. That says they actually moved to take me off of the case. You have to infer that. You have to mind read that, right? You have to mind read it. And so again, it might be that all these things together could convince the judge, well, I'll call this juror in here and ask him about this stuff, because none of them are direct smoking gun things. I'm in trouble again could have referred to he was a juror who was late one morning, although probably not this guy, or something he did that somebody scolded him for at some point and he's making kind of a joke about it or not. It could be that, or it could be my wife told me they tried to get me off of the case and that was trouble and all of that. I don't know about that one. Why would he say again if he's never in trouble? Well, yeah, right. But the question is, what's the trouble, right? So I don't know what that is. Yeah, I mean, a lot of people go to a lot of cases and that sort of thing. Let's see. So they say that shows that juror number one was exposed to information relating to defendant's motion to remove him. Does it show that? And if you're convinced that you think that it could lead there, because it clearly doesn't prove it, the next step would be for the judge to call the juror in and ask the juror the question and then see what the juror says and assess the juror's credibility compared to the circumstances. And that would be the next step if you are convinced of that. And they say he even continues to post about this case and said he needs to be, he respects that he needs to be careful about what he says at this point. And they make a point, I think, at some point here. Yeah, here it is. The group advised him to be careful regarding what questions he asked, and a new trial could be granted if he says something now that implies he made up his mind. Yeah. Now, while you're free to talk about things, as we talked about at the beginning of the stream, if the thing you talk about happens to be, I took money to vote the way I voted, then, and you don't want the verdict overturned, you do need to be careful not to say that, because that's admitting misconduct. Now, on the other hand, you could say, well, therefore, why does he need to be careful? Sorry, if he didn't do anything wrong, he doesn't need to be careful. He can just talk about whatever he did because none of it's wrong. So in the middle somewhere there is, well, I probably just better shut up because I'm attracting attention to myself and I don't want to upset this jury verdict, even though I would really like to talk about it. That can also be the middle ground there. So it's hard to say there. Now that somebody says the juror will lie, he wouldn't admit it. That's possible, and it's possible. It's possible that he'll say it didn't happen because it didn't happen. Now, if the judge calls the juror in and the juror admits it, you're looking at a new trial. If he calls the juror in, which isn't a foregone conclusion, and the juror says, I didn't do it, then it's up to the judge to assess the credibility of this person, what they said, and the circumstances around it, because you don't know that. I'm not going to call this guy a liar for certain, for one thing. He hasn't been put on a stand to talk about it. And here they talk about he joined Law and Lumber YouTube live stream and paid a super chat $100 to say he'd be happy to discuss the case with him, and that's in italics. But it's okay for him to discuss the case at that point. And then Rob says maybe you ought to talk about plaintiff's counsel before you start doing that. And especially if the juror number one agreed with the outcome. Well, obviously he did. He voted for the outcome. and therefore wouldn't want to jeopardize the result, it might be a good idea to talk to the plaintiff's lawyer, who probably would say, could you hold off? Because it doesn't do Maya any good to have jurors out there talking, because she's got the verdict. So if you're the one who loses, you want the jurors out there talking, and hopefully they'll say something that could result in the case being overthrown. So that's a good comment by Rob, and good. I'm not going to call it advice, but it's just generally the right idea there. Why are you sending $100 to a stranger? Well, I guess he wanted to let Rob know he appreciated his commentary on the case, and probably by that time had heard from his wife how much she enjoyed that stream, because Rob does a great job with it, and he was happy to discuss the case with him. It's a generous donation, and if a juror from the case popped in here and gave me $100 and said, do you want to talk about the case? I'd go, let's just don't do it. How about that for right now? But I might not say that. I might go, sure, let's talk about it. Let's do it. Let's go, because you didn't do anything wrong. So I'd like to know how you felt about it. What were the crux issues? I mean, if we even if we had a case in the middle of it, like I was saying last night on the other stream, and settled it or something like that, both sides would go talk to any juror members who were willing to remain around and ask them how the case went, what they thought was important, and stuff like that. You want to hear the jury's insights on it. Somebody says he's insanely biased. Well, I didn't see his stream, and I guess by that you mean that he thought that Maya should win a lot. Now, I will say by the end of the case, I was probably in that court from my perception of how the hospital witnesses were coming across and some of the things that were going on. But I can't say that I know, because I didn't see the whole case. But I could see how one would not like how they were behaving, and that's for sure. I could see that. Well, juror number 1 used the Charlie Adelson defense. I was being extorted and afraid to say anything. And I don't think so, but I like that joke, so I appreciate that. And I think juror number 1, if called in, likely would say, hey, my wife was interested in the case as it occurred. It was occupying my life. I was gone every day on this case, and she watched it, but we both respected the fact that when I came home, that wasn't anything we could talk about. And that's probably what he'll say. And that could be true. You don't know that it's not true. I mean, would I put the side eye on it and go, at that level of activity, did y'all discuss it? Now, come on now. I would probably do that, but it doesn't mean that it's true. And then he's talking about, they're talking about the fact that the juror knew that this motion was coming. So we're listening to counsel. It ain't over yet. And yeah, well, it ain't over yet, because there's all these post-trial motions and things like that. And then he talked about more stuff. He commented on Rob's stream and things like that. So here's another one they say that shows that he was also either not only talking to his own wife about this, but when he shouldn't have been, but also was doing maybe some research. When it comes to creature comforts, were you made to feel comfortable, or were you just made to, or just felt that you were in a hostile place? And so they say the phrase creature comfort was not used by any witness at a trial, but it is used on Dr. Kirkpatrick's RSD Foundation. And then they show that here. So that's their evidence that this guy researched this. Now, if you put away the wife, let's say he was divorced and there's no wife in this picture, or this wife was on a mission trip somewhere and was not commenting on this case, and this was the alleged misconduct, I think we'd all probably laugh that one on out of here. I don't think so. Whether that's a coincidence or not a coincidence, I don't think they're going to launch an investigation into the trial over that one. They say he denied watching the documentary, denied having any conversations concerning the movie. This seems unlikely, given the wife's heavy engagement, investment, and close monitoring of the case, the docket, and following on social media the movie producers. Seems unlikely. Which standard does that meet? It certainly doesn't meet the standard of throwing the case out. Does it meet the standard of, in conjunction with everything else, that, well, we ought to at least call this person in and ask for it? So I think they're getting down to they're getting down to the summary theory here. So the 2 steps: do you call this guy in and maybe his wife in and ask them, did you talk about this case or not? It's a lower standard than, of course, throwing the case out, because the first one is just the judge doing some investigating. So can you meet that standard? Is all of this enough smoke that the judge ought to see, did somebody light a match here or not? If you don't reach that, then you're certainly not going to get the verdict thrown out. And if you do reach that, I'm interested in terms of thinking about whether it's enough to show that they talked to each other or not. Because these are their facts. They're saying this is what happened. The wife can talk about the case. She can come to the case. That doesn't get a verdict thrown out. He can talk about the case when the case is over. That doesn't get the verdict thrown out. The question is whether they're able to show, based on timing and the content of communication, that the wife and the husband were talking about the case, because let's assume that they're going to both say that they didn't do it. Obviously, if they said they did do it, we wouldn't really have any argument over it. So let's say they aren't. So putting aside whether Maya's great and the hospital's terrible, or the hospital got screwed and it's a runaway verdict, the question narrowly on this motion is there enough here that the judge ought to at least ask this guy, did you do this or not? Did he meet that standard? And then also, do you think he met the standard as, hey, if this stuff is true, this verdict should be thrown out? So somebody says, will the plaintiffs respond with their own motion to dismiss? They won't do that because they got the verdict. What they likely will do is file a response to this motion, and they'll talk about all the things like they may have some evidence. Okay, I don't know. They might get an affidavit and say from the wife and the husband, say, we never talked to each other. That could happen. They'll probably argue how to distinguish the cases that are cited by the plaintiff. There's certainly, I'm sure, a lot of law here. I meant cited by the defendant. A lot of law here that isn't in the defendant's brief, talking about how hard it is to get a case overthrown, because they the way they run through the legal standard makes it sound like you just walk through these steps, boom, the verdict's out. And while I think they were accurate in everything they said, there's going to be other cases that say, but no. I mean, again, look at the Adelson thing. There were some people that were like, oh my God, the jury has exposed this case to being overthrown. And the judge said, I'm not going to look into this chat stuff. Now, again, should the jury have set up a chat group during the course of the trial? I would advise, don't do that. Don't do that, because it could raise the issue of, why do you need to be talking to each other while the trial's ongoing about anything, even exchanging personal contact? You guys should just be nice to each other and sit in there and listen to all this. And then when it's over, you can be friends or whatever. But even with that, the judge said it's not even enough. So I see here one says hurdle 1 probably met. In other words, at least ask these people. Hurdle 2 depends on hurdle 1. Now, the hurdle 1 would be interesting if Maya's side can get affidavits, if they want to, from the wife and the husband who say, we never talked about this case to each other, because that is hurdle 1. Hurdle 1 would be the judge calling them and saying, did you talk about that? They might be able to circumnavigate that by just saying, here they're already saying under oath they didn't do it. So now judge decide on these facts. Did it happen or not? Now somebody says creature comfort was in fact mentioned in trial. So that's, if that did happen, and if the plaintiff's lawyer has that information, that just knocks that one right out of the ballpark probably, right? Not that I thought that amounted to much anyway. So, yeah, can't catch anything about, I guess one of the lawyer's wife was talking about the case too, which, they can do that too. And the other thing, of course, is if you're a lawyer on a case and your wife wants to talk about it, the lawyer's already biased, so they're not a fact finder in the case, so that's okay. Let's see. The judge could assess jurors one's credibility from watching him, so that's questionable. And the judge may have some degree of opinion on that already. Sure, they were in the courtroom together for quite a long time. And then I know somebody else says they heard creature comfort as well. So that would be a bad thing to be wrong about if you were filing this motion, if you're wrong on a material fact like that, because I would certainly put that in a big banner if I were the plaintiff responding to this. So yeah, if you're going to file a response, you want to go, well, they're not even right about the facts, judge. First of all, the law is not like they say, because they give you an incomplete picture of it. It's a very tough burden to meet. Secondly, they're wrong on the facts, and they're trying to create a picture here that just didn't exist, right? And you can expect when you win a $250 million verdict, you're going to have to do a lot of lawyering to get it eventually. Long way between a verdict and a check. A long way, and a lot of paperwork. Can they subpoena their technology? I don't know if the judge is going to let them do that or not. They did ask here for an emergency order to tell them not to destroy any evidence. And that has happened for a juror in the past. And we'll see here if the judge goes, yeah, I'm going to order that, then you could expect it'd be fair to think they might have to provide that. But if the judge says, I'm not doing any of that, then no, you're not going to be able to do all that. Let's see. The judge isn't very smart. I thought he was pretty smart, but you may have watched more of it than I did. He seemed all right to me. Subpoena Netflix. That's a good one. Is it sketchy that juror number 1 went to Anderson for legal advice? At the end of the case, he had sided with Maya. So let's take it out of the equation that there's misconduct before that, because that's what we're talking about here. So the case is over. He wants to go give an interview. If he were to call Anderson and say, hey, what do you think? Should I give it this interview or not? And Anderson says, well, from our side, we prefer you don't. I think that's fair. And I talk to jurors sometimes after cases were over, well after they were over. So I think that's not necessarily bad in and of itself. If somebody said an 11-year-old doesn't self-harm, that seems ridiculous to me as well, if that happened, because they can do that. Whether this one did or not is a separate issue, but they certainly can. It seems like that happens younger as the time goes on. Hospital still doesn't get it. They don't understand how they reviewed. I agree with that. I really feel like they, even if they didn't do anything wrong here, how about a little bit of humility there? You're not perfect gods and everything you say is right. And that's how some of their witnesses struck me, to no willingness to consider the potential for their own error or anyone else's viewpoint. So that's when I was starting to lean the plaintiff's side, was how the defense witnesses were coming across to me. And someone saying, well, she's speaking like she knows firsthand. Yep. So I hear you on that. So I think because of how much of this there was and the comments, see, the spouse is not only commenting about, go Maya, I think Maya's right. She's also talking about, in some instances, what the jury might be thinking, and they'll be asking questions. You're getting closer to the line there of creating a perception that maybe there's some communication going on. And so you get closer to that first hurdle. And the hospital saved Maya's life, and it's certainly, perspective one can have. I get that. Juror questions weren't signed. I think they do know, or at least the judge knew who they were from, and maybe they were also telling that may be how they accumulate those in Florida. They may be by who is submitting them. Let's see here. And another one saying the hospital saved Maya's life. The mother almost killed her. I hear all that. It's whichever side I think you come down to, this is a complicated situation. But I will say this, even if the hospital did save her life, I still think in terms for litigation purposes, they need to work on their witnesses, because in my opinion, they were aloof and arrogant, the ones that I saw. Not all of them. I saw a nurse who I thought was really nice and stuff, but some of them are like, I could see a jury thinking, we might need to teach you a lesson now that you're out of your ivory tower and down here in the courtroom. We might have to show you something. You got to pay attention to how you come across if you're a witness, if you care. If you don't care, that's fine. Right. And you get what you get, which is a $250 million verdict. And that's going to make some lawyers very happy, because this is, this whole brief right here, it's all billable. It's all billable to somebody. So somebody's having to pay to do all this. So anyway, but that's this motion, and I think it puts it out there, and you can kind of decide what you think about the conduct of, was there communication, not whether the wife talked about the case. That's true, and all that. And there's no evidence that the juror number one talked about the case publicly before it was over, and he can talk about it when it's over. So it's down to whether they talked about it during the case. Well, still reading these comments, but I also promised I wouldn't drag this out, but it's so long, so I will stop doing that. But I'll look at the comments on the video later if you guys want to come in with some stuff or correct me where I may have been wrong, because I'm not an expert on this case, but just kind of wanted to settle this down in terms of what's the legal standard here, and boil this down to what you really should look at and what the motion is about. But anyway, it's time to start. I hear dishes rattling to get ready for Thanksgiving coming later. So I will talk to you guys later. Thanks, and bye.